Okay, good day, gentlemen. At the last lecture, we treated remedies of a judgment creditor. So today we are going to look at the remedies of a judgment debtor and thinking of the meaning of judgment debtor. Judgment debtor definitely is just like the opposite of the other side, judgment creditor, judgment debtor. So we can still define a judgment debtor to be someone against whom a judgment has been given, no matter the kind of judgment. And then if it's purely monetary judgment, that person who by that judgment is indebted to the judgment creditor is, in other words, the person called the judgment debtor. So we want to consider the options available to a judgment debtor. One of the options which we must definitely touch on is we first of all have to find out what kind of judgment that has been given against the judgment debtor. Is it a judgment on the merit? Is it a default judgment? Now, if the judgment against the judgment debtor is a default judgment, like we will learn, he will have the right to apply that the judgment be set aside. You can apply that the judgment be set aside. So that application to have the judgment set aside is one of the remedies available to a judgment debtor. Applying to have a judgment against him, which is a default judgment, set aside. Remember also that we have discussed how a default judgment could be given against someone either for non-participation in the pretrial proceedings or for non-appearance in the matter to defend himself, in which case the court will just give a judgment against him, or if it's maybe what we will call summary judgment procedure, whereby a party who is claiming a particular amount of money against a defendant files what we call summary judgment procedure, in which case, once it is served on a defendant, all the defendant needs to do is either to dispute the claim or to say, yes, I'm owing this money, but there's a set of, in other words, to show that he has a defense on the merit. But where maybe he was not served, something just happened and judgment was given against him, such a defendant can apply to have the judgment set aside. So that is one of the remedies available to a judgment debtor in case where the nature of that judgment is default judgment. Now, what about final judgment? What if the judgment against the defendant, pick this call. Tell me this one makes sense. So let me just give up. So what if the judgment against the defendant is judgment on the merit, is a final judgment on the merit? Does he have any right, any remedies as far as the judgment against him is concerned? Yes, of course, we can look at 2 or 3 remedies available to a judgment debtor. Now, one of the remedies available to a judgment debtor in a judgment that is on merit is to comply. To comply with that judgment is also a remedy. Why? Because if he doesn't comply, he faces the consequences, which may not be pleasant to him. So that's why we look at compliance as one of the remedies available to a judgment debtor. And then apart from compliance, we can also have an application for instrumental payment, if the judgment against the defendant is a monetary judgment, or damages have been awarded against a defendant who doesn't feel like appealing against that kind of judgment, he can go ahead to file an application to be allowed to pay that judgment sum against him instrumentally. And all he needs to do is to file a motion accompanied by an affidavit and his written address and any document to substantiate the reason why he cannot pay at once, why he would want the court to allow him to pay instrumentally. Same with this one. Why he wants the court to use an application for instrumental payment. Why? Because such an application is not granted as a matter of right or a matter of course, but rather upon the discretion of the court. The court in that fundamentally, in your affidavit, you have to state how you intend to pay the money. And not how you intend to pay the money is not ridiculous. It's not something that is grossly too low. For instance, let's say that the judgment sum is about 5 million naira, and somebody a joke. The court is not likely to grant that kind of application because you check if is allowed to repay 20,000 naira yearly, how long would it take him to offset the amount in issue? And then what about the person who has won in court? He has the right to enjoy the fruits of his judgment. So that kind of application looks more or less like makes an attempt to frustrate the judgment creditor. So in situations like that, the court may not likely, most likely, grant that kind of application. But if, for instance, somebody is proposing, I'm owing 5 million naira, I want to make a down payment of 500,000 naira and possibly 300,000 naira per quarter, the court may still look at it and consider it one way or the other. And then also too, the court will also consider the position of the judgment creditor. The judgment creditor may accept or he may not accept. And in which case, if he's not accepting, he has to file a counter affidavit trying to show the kind of prejudice that you will suffer if the application is granted. And he may also suggest that such an amount that the judgment debtor intends to pay instrumentally be upgraded or be added for him to be able to accept. In most cases where parties cannot actually agree on what is reasonable, the court will have the right to make orders as to what it thinks reasonable in their very circumstance. And then again, the next one is appeal. Remedies available to a judgment debtor. The last one is appeal. A judgment debtor has the right to appeal against the judgment against him. So I'm not going to be discussing the steps of appeal because I think that is going to be one of the topics we're going to treat, possibly the last topic we're going to treat. So bear in mind that somebody who has a judgment hanging on his neck, who is now a judgment debtor, has remedies which include applying to set aside the judgment depending on the kind of judgment. If it's a default judgment, secondly, he can comply. Thirdly, he may decide to make an application for instrumental payment, or fourthly, he may decide to appeal against that very judgment. So moving from there, I want to look at the next topic, which is post-judgment applications. Post-judgment applications. Post-judgment applications simply mean those applications that parties are allowed under the law to make after the judgment of the court had already been given. And one may want to ask, why talk about post-judgment applications. Why talk about post-judgment applications? They are very, very important in that the law is that once a court has given its judgment, the court's hand becomes tied. The court cannot again dot an I or cross a T. In other words, that court becomes functus officio. The official duties of that court have come to a full stop. Not just a stop, but a full stop. So the court is not permitted by law to do any other thing after having delivered its judgment. But there are applications that the law has permitted that can be made and entertained by a judge who has already concluded a matter and delivered judgment. So those are the post-appeal applications. So we're going to look at the types of post-appeal applications and the nature of those post-appeal applications. And now these applications are not the exclusive reserve of any party to the suit. It's not like only a reserve right for the judgment debtor or the reserve right for the judgment creditor. Rather, it depends on the kind of application. Either party may have the need to make an application after judgment had already been given. The first one may be an application by the judgment creditor himself. Judgment has been given in your favor, but you still need to make an application in respect of the judgment already given to you, and then also still be entertained by the judge. Now, when we talk about application, we approach the issue of application from two perspectives. The first one is administrative application. That application that the counsel to the claimant can make to the registry of the court and then have the blessing of the judge in the end, endorse it. In other words, it's not going to be an application by way, it is not the type of application that is brought either by way of motion on notice or way of motion ex parte, but just a letter written to the court for the registrar or court administrator to act on it, bring it to the attention of his lordship, and then have the application treated one way or the other. One of such examples of this kind of application could be an application for the writ of execution to issue for the levying of execution on the movable properties of the judgment debtor. So in this type of application, the judgment creditor or counsel on his behalf writes a letter. This is done within the administrative sector. A writ is filled and then taken with the case file to the judge. And when the judge signs, the judge ensures that, first of all, that the time for the execution has ripened. It is time to execute the judgment of the court. And the court judge will also look into the case file to ensure that there is no notice of appeal and any other application that may stall the granting or the signing of that writ. Because when that writ of execution is signed, the bailiffs of the court and the staff of the relevant staff of the court will move to levy execution on the properties of the judgment debtor and destroy the properties of the judgment debtor, which may be sold if he does not pay off the judgment debt against him. It may be sold in order to satisfy the judgment sum. So that's talking about that kind of application that can be done administratively from the side of the claim judgment creditor now. And now another application that the judgment creditor can also bring before the court can be an application by way of motion on notice for the correction of slip, error in the judgment of the court. And one may want to say, can a judgment of the court be corrected after it had been delivered? The answer is, as a general rule, no. But as an exception, if the correction sought to be effected is a minor slip, a minor mistake on the side of the judge. Maybe the judge wanted to mention judgment debtor and he's talking about judgment creditor. Maybe I hereby order the judgment creditor to pay the sum of so amount of money to the judgment creditor. So mere looking at it, you know that that is an error. Or it may go this way, that the court hereby directs the judgment debtor to pay the judgment sum to the judgment debtor within a particular number of days. We also discover that there is an error there. The court may also erroneously, maybe still while stipulating time for performance, may just erroneously fix it on a date, maybe on a return date that is not feasible, maybe on a Saturday or Sunday. Judges are human beings. So when you see such mistakes, those are simply errors. Or maybe the judge, after evaluating the evidence of all the witnesses, maybe one at a particular point in time, he wanted to stress a point made by PW1 and he's calling PW1 PW4. That's a typography, that's a mere error that could be corrected. Or let's say while writing the judgment, the judge wants to name the claimant by his name, and instead of writing Williams, he wrote Dennis. So the judgment creditor can file an application for that slip. You call it slip, which means a minor error. It could also be a misnomer. That is when you wrongly, name somebody, pronounce somebody's name or write somebody's name wrongly, out of mistake. So the law looks at such a mistake as mistakes that are innocuous. They are not serious in nature. They are not harmful mistakes, right? And then also to a judgment creditor can also, by way of motion on notice, bring an application to the lower court, the court that has heard the matter and deliver the judgment before an appeal is filed. He can bring an application seeking the coercive power of the court to order that a particular sum of money or property belonging to the judgment debtor that is within the jurisdiction should not be taken out of the jurisdiction until maybe his appeal, until his time of appeal elapses. It is still within the confines of the jurisdiction of the court within that period or in time to do what? To protect his judgment, to ensure that the execution of his judgment will not be rendered nugatory by the act of the judgment the debtor removing his property from the jurisdiction of the court. Inasmuch as that we have noted that in law, judgment of the court can be enforced at any place in Nigeria. All right. Then we also look at some other things, that some other applications that a judgment creditor can bring. A judgment creditor can also bring an application for committal of the judgment debtor for contempt of court in appropriate cases. Where in appropriate cases the judgment debtor has failed to comply with a specific order of the court mandating him to do a particular thing within a time frame, or restraining him from doing an act, and he has disobeyed the order of the court in the judgment, that's the judgment order of the court. And what I heard to do what he's not supposed to do, what he has been restrained from doing, or failed to do what he has been asked to do. Then the judgment creditor can proceed against the judgment debtor in contempt proceedings, first of all, filing what we call Form 48. Form 48 is that form that reminds the judgment debtor of the judgment against him, the judgment order against him, and asking him that except he complies with this order within so time as has been stipulated by the court, that he will be committed to prison. Form 48 is normally endorsed behind a copy of the judgment order. Form 48 must be endorsed. In other words, if I have a paper in my hand and in front of the paper is the judgment, so I will need to print Form 48 at the back of the judgment order. I need to, not attaching, but it must be what? Endorsed. So it must be printed at the back of a copy of the judgment order and serve on the judgment debtor. And now, after the stipulated time in that notice of consequences of disobedience, and the judgment debtor fails to do something to remedy the wrong, now the judgment creditor will go ahead and file another form called Form 49. Form 49 is the form that commands him to show cause why he should not be proceeded against in contempt for having disobeyed the order of the court. Now, when that form is filed at the expiration of the time frame of the court order, a motion on notice is brought, as that is the motion that will now commence the committal proceedings. The pattern for committal proceedings are explicitly, can I have the rules of court, provided in the rules of the court. They are explicitly provided in the rules of the court. Let's just maybe have recourse to what is stated in the Abia State High Court Practice and Procedure Rules on the issue of contempt proceedings. On the issue of contempt proceedings. Just a little while I'll be there. All right, that's Order 53. Order 53 of the Rules of Court of Abia State. By the provision of Order 53 Rule 1, it says the procedure in applications for attachment for contempt of court in cases to which this rule applies shall be made the same as applications for order of judicial review under Order 40 as far as may be applicable. In other words, the pattern here is to be by originating motion, which is also going to be on notice. Sub 2 says, the notice of motion shall be personally served unless the judge dispenses with service. Judge can only dispense with service when you have tried to effect personal service and it appears the contempt no, that's why you will be right to describe him as such at this stage, that the contempt no is a vetting service, in which case you go back and look at the appropriate provisions of the rules of court and bring an application for substituted service of that very originating process of originating motion to be served on the contempt no by any substituted means as the court would grant you to follow. This rule applies to cases where the contempt is committed. A. In connection with proceedings to which this order relates, In connection with criminal proceedings, that's talking about civil and criminal contempt, subject to the provisions of the Sheriff and Civil Process Act, any proceedings in the High Court where the contempt consists of disobedience to an order of the court. So contempt follows, contempt proceedings is a response to a disobedience or disobedient act by a party in a matter before the court in connection with the proceedings in an inferior court, provided this rule shall not apply where the contempt is committed facie curia, where the contempt is committed facie curia, that is outside the court, where maybe it is a bit extraneous with what has happened in the court. And then rule 2 talks about the procedure on disobedience to court order, and it says when an order enforceable by committal has been made against a judgment debtor, and if the order is for delivery of goods without the option of paying their value, or is in the nature of an injunction, the registrar shall, when the order is drawn up, immediately endorse it as follows: the notice of consequence of disobedience to order of the court. Just like I have told you, and the contents will read, take notice that unless you obey the directions contained in this order, you will be guilty of contempt of court and will be liable to be committed to prison. This is order 48. Order 48, as provided for in the Sheriff and Civil Procedure Act under the schedules, is the same from 48 that Order 53 sub rule 2 of the Abia State High Court Practice and Procedure Rules 2021 provide for. So that is one of the applications that a judgment creditor can also make. And then we look at the judgment debtor. Is he entitled to make any applications? Are there any applications that the law permits the judgment debtor to make? Yes, there are many orders, there are many applications a judgment debtor can make. One of such applications is one, an application for stay of execution of the judgment of the court. When a court has made an order in his judgment, maybe for an act that must be performed, then such as payment of money into the court or payment of money into the account of the judgment creditor. If the judgment debtor has reason to appeal against that very judgment, then the judgment debtor is obligated under the law to first of all file his notice of appeal. That's the first step. Once he has filed his notice of appeal, he will also file what is called motion for stay of execution of the judgment. And once he has filed the motion for stay of execution of the judgment, he must support it with an affidavit and written address. His affidavit must show why he is seeking for an order of the court staying the enforcement of his own judgment. One of such things he has to satisfy the court is that, one, that he has filed an appeal. That is to say that he has filed a notice of appeal, inasmuch as the law is clear that a notice of appeal does not operate as a stay, but a notice of appeal filed and followed subsequently by a motion for stay of execution will operate as a stay even before it is heard. So if you're the judgment creditor and the judgment debtor has served you a motion on notice for stay of execution to which that notice of appeal is attached, showing that he has taken steps to appeal, then for God's sake, you are to do what? Maintain the status quo. You're not expected to ignore that motion, maybe to go ahead to levy execution or to do anything that will frustrate the hearing of that motion for stay of execution of that very judgment. Why? Because the judgment debtor also has the constitutional right to fair hearing. So that's why once he serves you with that notice, you must respect it and allow the notice to take its course. Let it be argued. Let the court hear it and take a decision one way or the other. Now, like I have said, I did mention a judgment debtor. Sorry, actually, the judgment debtor also has a right to make an application for instrumental payment. If, for instance, he has agreed to pay, but he is not in a position to pay everything at once, he can bring an application to that effect. Then you can also bring an application to set aside a null judgment. You can bring an application to set aside a null judgment. We have talked about that a judgment debtor can apply to set aside judgment obtained by default. You can apply to set aside judgment obtained by default. Similarly, if that judgment was obtained by fraud, and then it is suddenly found out that there was concealment of facts, maybe while the case was going on before it was determined, the now judgment debtor, had a conference with the judgment creditor as to how to settle the matter out of court. And maybe he goes ahead to satisfy the whatever is the terms of settlement. And then the judgment creditor hides or conceals this very fact from the judge. And the judge goes ahead to give judgment. Then that judgment becomes what? Null and void. Because there is fraud. It could be that the judgment debtor is actually indebted to the judgment creditor to the tune of, let's say, 10 million naira, and that was the cause of action. The claimant sued him to recover 10 million naira. And while the matter was still going, they decided to discuss outside the court and say, my friend, you see, things are very difficult. Could you please accept 7 million? And they say, if you give me 7 million, that's okay. And he paid 7 million, and with all good conscience, believing that the claimant will withdraw his case. But instead of the claimant withdrawing his case, the claimant went ahead with the matter until judgment was entered in his favor in that matter. The judgment debtor can bring an application to set aside the judgment on the ground of fraud. And that is why when a matter is pending and parties have agreed to settle, parties in their own interest have to execute what is called terms of settlement. They must execute what is called terms of settlement. The idea of executing terms of settlement is to ensure, that there is documentary evidence to show that parties have settled, and the terms of settlement also stipulated documentarily. Not only that, don't stop at executing terms of settlement. Ensure that terms of settlement is filed in the court. And when you file the terms of settlement in the court, ensure also that you make an application that the terms of settlement should be adopted by the court as judgment of the court. Yes, as judgment of the court. That is what is called consent judgment. Now, if a consent judgment has been entered, it gives both parties the assurance, especially the would-be judgment debtor, the person who would have been the judgment debtor. It will give him the assurance that, this man has accepted my proposal and we have agreed and it has become the judgment of the court. And I have already satisfied the judgment of the court. Assuming he has not satisfied the terms will also stipulate steps which you will take to satisfy the terms of settlement. Maybe, for instance, say he may be paying maybe 3 million naira every year until the balance, the first deposit is paid, and then the balance will also be stipulated when the balance will be liquidated in terms of the terms of settlement already agreed by the parties. But what if a consent judgment has been entered and the judgment debtor, the other party now, because there won't be, let just for our own understanding, the terms of settlement has been entered as a judgment of the court, and which means the party who is to satisfy most of the obligations stipulated in the terms, most of those obligations stipulated in the term becomes the judgment debtor. Let's assume that he suddenly discovers that fraud had been played upon him. Can he apply? Can he make any applications whatsoever? The answer is yes. We approach this answer from the purview of the fact that a consent judgment is not appealable. You cannot appeal against a consent judgment except it is shown that it was obtained by fraud. So if it is shown that a consent judgment has been obtained by fraud, the judgment debtor will have the right to make application to set aside that very judgment. So you will have two options and may choose between making an application to set aside the judgment or to appeal against it, because his case falls within the exception that although consent judgment is not appealable, but where is a judgment obtained by concealment of fraud, then the judgment debtor can apply to set it aside or can appeal against it. So that is, if he chooses to apply to have it set aside, we now say that he is bringing a post-judgment application to have the judgment set aside. And then again, he can also bring an application. He can also bring an application to stay the sale of different properties that was subject of execution of judgment. What I mean by this is that if the judgment has been levied against him and his properties have been taken away to the court premises pending when the properties will be sold to satisfy the judgment debt, the judgment debtor can bring an application to stay or to stop the sale, and then he will give reasons why he has brought the application. His reasons could be maybe that the execution was levied wrongly. So if he can show that the execution was wrongful execution, for instance, if the judgment itself is null and void and execution had already been levied before the property is sold, he can bring an application, first of all, to do what? To stay the sale or to stop the sale of his property pending what? The determination of his appeal. In which case, he also has to show that he has filed his notice of appeal. This application is different from stay of execution. Why? Because execution had already been levied. So he can bring an application to stop the sale, because once execution is levied, the next step is to sell the property. So he can bring an application for the sale of his destined property to be stopped pending the determination of his appeal. And then again, if contempt proceedings has been instituted against him, if contempt proceedings has been instituted against him, he can also make an application in respect of the contempt proceeding against him. What can he do in that wise? If, for instance, he has filed an notice of appeal as well as application for stay of execution, under the law, he cannot be found guilty of contempt of court. Why? Because the contempt of court, that order that you said he's in contempt of, he has appealed against it. So, which means he has somehow taken out the jurisdiction from the court and has pushed it and vested it on the Court of Appeal. So, once that is done, he can bring such an application to say that, look, this contempt proceedings against me cannot, in law, go on. Why? Because the court would have no jurisdiction to proceed or continue with the hearing of the contempt proceedings, because he has already filed his notice of appeal, and then he has also filed an application for stay of execution. So we have been able to look at post-judgment applications, and we have summarized it to say that both parties can apply depending on the circumstances of their case and exactly what they are seeking, what prayers they are seeking the court to grant them. And if such an application, for instance, an application for stay of proceeding, if it is refused, application for stay of execution, sorry, if it is refused at the lower court, nothing stops the party who made that application, the judgment debtor, from filing the same application at the Court of Appeal. So when he files that application at the Court of Appeal, he can also notify the lower court, just in case there are steps that the judgment creditor has decided to take further against him, so that the court will know that it no longer has jurisdiction to entertain any further applications. Why? Because his application is pending at the Court of Appeal, and it will also be disrespectful of the lower court not to respect an application challenging its own decision, which is now pending on an appellate court that is higher than it. So far so good. We have been able to look at the remedies available to a judgment creditor, as well as the remedies available to a judgment debtor, and post-judgment applications, what can be the subject matter of such applications. So thank you very much. We'll fix a date for the next lecture. Thank you.